Hello, my name is Paul Komesaroff. I would like to welcome you to the series of recordings from the Monash University Workshop on Voluntary Assisted Dying, which was conducted over 5 sessions between the 18th and 26th of July 2022. Before I proceed, I'd like to acknowledge the traditional owners of the land on which I'm located and to express my respect for their elders past and present. Our meeting was organised as part of an ongoing research project examining the impact and consequences of the introduction of legislation in the state of Victoria, Australia, to legalise voluntary assisted dying. The Victorian Voluntary Assisted Dying Act was passed in 2017 and its operation commenced in June 2019. It was the first such law in Australia, as a result of which its impact has been very closely scrutinised. The broad outlines of the Act are well known, and I won't repeat them here, apart from to make some very brief points. The key purpose of the Act is to provide for and regulate access to voluntary assisted dying, or VAD, in the state of Victoria. Persons eligible to access VAD under the Act are those with decision-making capacity who have been diagnosed with a disease that's incurable, advanced and progressive, is expected to cause death within 6 months, and is causing suffering that can't be relieved in a manner that that person considers tolerable. Under such circumstances, they're able to initiate the process leading up to VAD. This entails at least 2 assessments by medical practitioners, including one who has particular expertise in the disease in question. Once the administrative process is complete, a certificate may be issued, as a result of which the person is provided with medications which he or she may consume in order to bring about the end of their life. As expected, in Victoria, as elsewhere, the subject of VAD has been very hotly contested. The trailblazing Victorian Act responded to public concerns by incorporating a large number of so-called safeguards. It's said that there are more than 60 in all. Some of these are substantive and some merely procedural or administrative. While they've been welcomed by many, they've also been criticised by others as imposing an unreasonable bureaucratic burden on individuals who are already under great stress. Our research project is undertaking a prospective study of the impact and consequences of the introduction of voluntary assisted dying in Victoria. This involves collecting qualitative and quantitative data from representatives of all the major stakeholder groups, including patients, families, carers, health professionals, regulators, and community members. Our data have identified a wide range of social, ethical and legal questions about VAD and many concerns about the potential impacts on individuals, communities and society as a whole. In this workshop, we sought to address a selection of these issues through a series of 5 reflective dialogues over a period of about a week. The 5 sessions were as follows. First, there was an opening plenary which examined some of the key issues regarding the impact of VAD on medicine and society, with reference to both national and international perspectives. Second, there was a discussion of participant experiences of VAD. Third, there was a workshop on legal and administrative considerations. Fourth, there was a session on large and small-scale societal impacts. And finally, there was a closing plenary on strategies for evaluating voluntary assisted dying in order to share our experiences with researchers in other jurisdictions. Each session was 90 minutes long and took the form of a series of brief presentations to set the scene, followed by a panel discussion with questions and comments from the audience. All sessions were recorded, and we are now, with the consent of the participants, making the videos publicly available to others who may find them of interest. Regardless of the background from which you come, I hope you find these recordings useful and thought-provoking. Thank you for your interest in them.